Hello, and welcome to the Kelso Report's Ethics Update for November 2011. 3 times a year, we produce an Ethics Update program which reviews all of the recent published cases from California appellate courts dealing with issues of professional responsibility, and all of the opinions from the Review Department of the State Bar Court, both published and unpublished. We will also review any recent major developments, such as rule amendments, to make sure you stay current on issues of professional responsibility. Now, in today's update, we will cover cases arising in the following topical areas. First, avoiding acts involving moral turpitude, dishonesty, or corruption. Second, Rule 3.100 and attorney-client confidentiality. Third, Rule 3.200 and prohibited objectives of employment. Fourth, Rule 3.300 and avoiding interests adverse to a client. Fifth, Rule 4.100 and preserving identity of funds and property of a client. And sixth, fees for legal services. So sit back and let's take a tour through some issues of professional responsibility. And our first topic is avoiding acts involving moral turpitude, dishonesty, or corruption. Business and Professions Code Section 6106 provides that every attorney has a statutory obligation to behave honestly and free of corruption or immorality. According to Section 6106, quote, the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, and whether the act is a felony or misdemeanor or not, constitutes a cause for disbarment or suspension. If the act constitutes a felony or misdemeanor, conviction thereof in a criminal proceeding is not a condition preceding to disbarment or suspension from practice, therefore, close quote. Now, not every felony is a crime involving moral turpitude, which the lawyer in our first case discovered. The lawyer pled guilty to 1 count of possession of child pornography. In the matter of Gary Douglas Grant, the Review Department held that the crime of possession of child pornography does not inherently involve moral turpitude in every case, but may involve moral turpitude depending on the facts and circumstances surrounding the conviction. Some crimes are, of course, so serious that they constitute moral turpitude in every case. They involve moral turpitude per se, because they are so extremely repugnant to accepted moral standards. Crimes falling into the moral turpitude per se category include murder or serious sexual offenses against children. More generally, moral turpitude has been described as an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow men or to society in general, contrary to the accepted and customary rule of right and duty between man and man. Well, the Review Department held that possession of child pornography is not a crime involving moral turpitude in every case because the circumstances surrounding the conviction may vary substantially. For example, it is one thing if the defendant actively searches for child pornography on the internet, but it is quite another if someone merely possessing child pornography possesses it after receiving it from an unsolicited source, which certainly can happen on the internet. The evidence in this case showed that the lawyer had been convicted of possessing 2 unsolicited electronic images, apparently of child pornography. After his guilty plea, he had been ordered to serve 90 days in jail, register as a sex offender for life, and complete 3 years probation with specific sex offender conditions, and he did not appeal the criminal conviction or sentence. The record in the disciplinary proceeding ended up being insufficient for the court to conclude that the conviction involved moral turpitude. The photos themselves were not produced by the prosecutor for introduction into evidence, and the prosecutor failed to establish the prerequisites for application of the secondary evidence rule. So, the testimony from the expert analyst about the pictures was ignored by the Review Department. In these circumstances, there was a big gap in the evidence, and the only thing the Review Department really had was the conviction itself. With this very limited evidence, the Review Department recommended only a 2-year suspension, but believed that disbarment would be unwarranted in the circumstances. Well, our next topic is attorney-client confidentiality. This is one of the most important responsibilities which lawyers have, both to their own clients and to the bar in general. Anytime a lawyer breaches the attorney-client relationship by divulging client confidences without consent, it makes it more difficult for all other lawyers to secure the trust of their clients. That is why Section 6068E1 of the Business and Professions Code is stated in such uncompromising terms. Section 6068E1 provides that it is the duty of every lawyer, quote, to maintain inviolate the confidence, and at every peril to himself or herself to preserve the secrets of his or her client, close quote. Rule 3100A of the Rules of Professional Conduct restates this as follows, quote, a member shall not reveal information protected from disclosure by Business and Professions Code Section 6068, subdivision E1, without the informed consent of the client, or, as provided in paragraph B of this rule, dealing with preventing criminal acts likely to result in death or substantial bodily harm. Well, we have a number of cases involving the attorney-client privilege, some involving its scope and some involving the consequences of breaching the attorney-client privilege. First, in Fireman's Fund Insurance Company versus Frontgate Plaza, the Second District reversed a trial court's decision which had adopted a narrow interpretation of the attorney-client privilege and the work product privilege. The trial court first held that the attorney-client privilege did not extend to communications among and between multiple counsel representing a single client. It was instead limited to communications only between an attorney and his or her client. Well, this narrow version of the attorney-client privilege would have virtually eliminated the use of multiple counsel, since when multiple counsel are present, there will inevitably be a lot of communication between counsel. The Second District held that the privilege does indeed apply to communications among and between multiple counsel, as well as others representing the client's interest. Second, the trial court held that the work product privilege applied only to an attorney's impressions, conclusions, opinions, legal research, or theories that had been reduced to writing. If the attorney's work product is not reduced to writing, according to the trial court, it's not protected by the privilege. Well, as with its first holding on the scope of the attorney-client privilege, this holding with the trial court is at odds with the way lawyers work. And the Second District reversed this holding as well, holding that the work product privilege applies to the impressions, conclusions, and opinions themselves, not just the written artifacts that record those impressions, conclusions, and opinions. Our next case involves the fallout from a lawyer's decision to disclose confidential information acquired in the course of representation to a government regulatory agency. The Second District faced this situation in Fremont Reorganizing versus Fagan, where a corporation's former general counsel and in-house lawyer, in response to being terminated by the company, disclosed to the insurance commissioner as liquidator of a related company that his former clients were planning to auction certain artworks that he claimed were owned by the related company. The insurance commissioner commenced an adversary action against the former client company in the liquidation proceeding. The disgruntled former counsel also filed an action against his former client for wrongful termination and other claims. In that action, the company filed a cross-complaint alleging, among other things, breach of fiduciary duty and breach of confidence. The former lawyer then filed a motion to dismiss under the anti-SLAPP statute, asserting that the cross-complaint arose out of his protected communications with the insurance commissioner. A cause of action is subject to a special motion to strike under the anti-SLAPP statute if the defendant shows that the cause of action arises from an act in furtherance of the defendant's constitutional right of petition or free speech in connection with a public issue, and the plaintiff then fails to demonstrate a probability of succeeding on the merits. The purpose of the anti-SLAPP statute in motion is to provide an early procedural remedy to dispose of lawsuits brought to chill the valid exercise of a party's constitutional right of petition or free speech. The Second District agreed that the communications with the insurance commissioner were protected activity under the anti-SLAPP statute, and that the breach of fiduciary and confidence claims arose from that act of communication. However, the court also held that the company had successfully demonstrated a probability of prevailing on its breach of fiduciary duty and confidence claims. The former attorney argued that California's general litigation privilege precludes liability on the breach of confidence claim, essentially contending that his disclosure was in the context of the insurance commissioner's ongoing liquidation proceeding. The court rejected this defense, noting that the litigation privilege, if applicable here, would preclude essentially any action by a former client against an attorney for breach of professional duties arising from communicative conduct in litigation on behalf of the client, and that would fundamentally undermine the attorney-client relationship. Based on the presumption that the former attorney acquired confidential information in the course of his representation, and the circumstances of the lawyer's employment termination and phone call to the insurance commissioner, the court concluded that it was reasonable to infer the lawyer used or disclosed confidential information in informing the commissioner, and that conduct probably constituted a breach of fiduciary duty and breach of confidence. Accordingly, the court held that it was error for the trial court to have dismissed those claims under the anti-SLAPP statute, and it remanded the case for further proceedings. So the lawyer's not out of the woods on this one. Courts will not permit the anti-SLAPP statute or the litigation privilege to be used as a shield by attorneys for unprofessional conduct and breaches of the duty of confidentiality and loyalty. Well, our third case here, every now and then, a lawyer will come into possession of documents that appear to fall within someone else's attorney-client privilege. That is what happened in Clark v. Verisign, where the plaintiff, who was terminated from his position as chief administrative officer for the defendant, provided to his law firm attorney-client privilege documents from his former employer, in violation of a non-disclosure agreement he had signed when originally employed. In these circumstances, the professionally responsible action is to refrain from examining the materials any more than is essential to ascertain if the matters are privileged, and then immediately notify the sender that he or she possesses material that appears to be privileged. In Clark v. Verisign, the plaintiff's law firm did not do that. Instead, it not only did not immediately return the documents, but it reviewed their contents and actually relied upon portions of the contents in the lawsuit. And that misconduct earned the law firm a disqualification as counsel. Now, when a lawyer represents a developer for several years, attempting to assist in securing city council approval for a project, learning confidential information in the course of the representation, can that lawyer, 2 years after his representation has ceased, publicly oppose the project before the city council and solicit signatures for a ballot measure opposed to the project? You would have thought the answer to that question was pretty obvious, but powerful, successful lawyers sometimes have a way of rationalizing almost anything. Fortunately, the answer to the Supreme Court of California was crystal clear. In Oasis West Realty v. Goldman, the client sued its former attorney for breach of fiduciary duty, professional negligence, and breach of contract. The former attorney interposed an anti-SLAPP motion, which is what was before the Supreme Court. Justice Baxter wrote for a unanimous court that the plaintiff easily satisfied its burden of establishing a probability of succeeding on its claims, and the anti-SLAPP motion should have been denied. The court relied upon its leading decision from 1932 in Wachumna Water Company v. Bailey, where the court explained that, quote, an attorney is forbidden to do either of two things after severing the relationship with a former client. The attorney may not do anything which will injuriously affect the former client in any manner in which the attorney formerly represented the client, nor may the attorney at any time use against the former client knowledge or information acquired by virtue of the previous relationship, close quote. The Court of Appeal and the defendant tried to limit this language to situations involving either concurrent or successive representation, or to the actual disclosure of confidential information. But the Supreme Court was not having any of those limitations. From its perspective, the use by the attorney of confidential information against the client's interests, even absent of disclosure, was unacceptable. The Supreme Court reversed the Court of Appeal and sent the case back for further proceedings. When you take on a client's interest, you take them on for life. That's what it means to be a professional. And now our third topic area, prohibited objectives of employment. As an officer of the court, one of the things lawyers are not supposed to do is file pleadings that are frivolous or have been filed solely for the purpose of delay or harassment. Rule 3200 of the Rules of Professional Conduct provide as follows, quote, "A member shall not seek, accept, or continue employment if the member knows or should know that the objective of such employment is A, to bring an action, conduct a defense, assert a position in litigation, or take an appeal without probable cause, and for the purpose of harassing or maliciously injuring any person. Or B, to present a claim or defense in litigation that is not warranted under existing law unless it can be supported by a good faith argument for an extension, modification, or reversal of such existing law." Close quote. Well, in our first case, the lawyer in the matter of Matania Iton, he dodged a bullet when the review department concluded that a legal position he had taken before the California Court of Appeal did not violate Rule 3200's requirements, even though the Court of Appeal had already determined that the appeal was frivolous and had sanctioned the attorney for taking it. Needless to say, the prosecutor's, state bar prosecutor's position was that the issue of whether the legal position was frivolous had already been decided, and the prosecutor argued that the review department should be bound by the Court of Appeal's prior finding. The review department disagreed. Relying on its own prior precedents, the review department explained that while issues arising in civil matters may bear a strong similarity, if not identity, with the charged disciplinary conduct, nevertheless, the purposes of the disciplinary proceeding are quite different from those of a civil proceeding, and the body of law is accordingly different. In addition, the standard of proof in a disciplinary proceeding is proof by clear and convincing evidence. So the review department conducted its own assessment of the legal argument the attorney had advanced. The prior case involved the proper interpretation to be given to a child support order. After a dispute arose about the amount of child support that was owing, the court held its first of several hearings on June 5, 2000. It issued a tentative ruling on August 29, 2000, indicating that the current amount due for child support is $208,000. It issued a final ruling 4 months later, and that order contained exactly the same language. Unfortunately, the order did not specify the effective date of the calculation of the arrearages, or when payment of the arrearages was due and payable. The lawyer's client paid the full amount of the arrearages as indicated in the order, but refused to pay any amounts that arguably came due between June 5, 2000 and March 1, 2001, when the final order was entered, arguing that the final order issued on March 1 found that the current amount due was $208,000. He filed a motion seeking a determination that his client had paid in full. A different judge heard that motion and ruled against the lawyer's client, concluding that the judge who entered the order did not mean to stop child support for a period of 8 or 9 months. It was just mistaken wording in the opinion. The lawyer appealed and repeated his contentions. The First District Court of Appeal not only dismissed the appeal, but sanctioned the attorney for pursuing a frivolous appeal, concluding that there was no reasonable basis to conclude that the child support did not continue to accrue between the hearing date and the date the order was filed. At the disciplinary hearing, the lawyer gave what to the hearing judge was a credible explanation for why he maintained the appeal. According to the lawyer, he was just trying to focus exclusively on compliance with the literal terms of the court order. He was not trying to assert that the original order for child support did not require child support payments during that disputed 9-month period. He was simply trying to argue that the arrearages order had been complied with, and that the arrearages order did not discuss payments during the disputed 9-month period. While the First District either misunderstood or rejected the distinction the lawyer was trying to draw, the distinction itself was not an unreasonable one. The review department found the reasoning of the hearing judge and the hearing judge's finding that the lawyer was credible to be determinative. The review department was also strongly influenced by what it identified as the strong public policy in favor of peaceful resolution of disputes, which requires attorneys to freely advance legal arguments and remedies on behalf of clients without fear of personal liability. Noting that it is difficult to maintain the appropriate balance that will ensure both that indefensible conduct does not occur and that attorneys are not deterred from vigorous advocacy, the review department announced that it remains cautious about establishing a disciplinary precedent that could have a serious chilling effect on the assertion of a litigant's rights. The review department affirmed the hearing judge's dismissal of the disciplinary matter with prejudice. Well, our last case in this section is a good reminder that playing games with the courts can end up being pretty costly. In Kane versus the Grand Holdings, a 15-year effort to collect $37 million in damages resulting from the defendant's purchase of one of its subsidiaries ultimately led to the imposition by the Superior Court of $75,000 in discovery sanctions. The plaintiff was attempting to prove that the defendant was the alter ego of a company, MTC, against which the plaintiffs had secured a $37 million judgment. The defendant repeatedly refused to provide the plaintiff with discovery pursuant to court orders, forcing the plaintiff on 2 separate occasions to file motions to compel. When they finally did produce 55,000 pages of financial accounting, banking, and transaction records, the plaintiffs discovered the records in a state of complete disorder, and they were forced to spend $75,000 of lawyer time to put them in order. Defendant claimed they turned the documents over in exactly the condition they found them. But when the court ordered defendants to produce witnesses who could so testify, the defendant produced 2 declarations of employees, neither of whom had personal knowledge of the condition of the records. The Superior Court granted the plaintiff's motion for sanctions, awarding the plaintiff the cost of putting the records in order, and the Second District affirmed. This is pretty clearly a case of discovery abuse by the defendants, and it is also clear that defense counsel has lost the trust and confidence of both the Superior Court and the Second District. This is not the right way to practice law. Our fourth topic, avoiding interests adverse to a client. As a general matter, an attorney must at all times avoid interests that are adverse to a client's interests. This principle finds particular expression in Rule 3300 of the Rules of Professional Conduct. Rule 3300 provides that, quote, a member shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless each of the following requirements has been satisfied. Now, before we discuss those requirements, let's stop for just a moment to review the basic limitation in Rule 3300. First, an attorney should not enter into a business transaction with a client. Now, the overall focus of the Rule 3300 is on adverse interests. The premise of the first limitation is that some degree of adversity is inherent whenever an attorney enters into a business transaction with a client. And this makes sense. No matter what the transaction, the attorney and client may well end up with adverse interests. Everything may start just fine, but every business deal carries with it the possibility of the deal going bad and the parties to the deal becoming adverse. So the best advice to counsel is simply to avoid business transactions with clients. Now, in addition to limiting business transactions with a client, Rule 3300 provides that an attorney should not knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client. This limitation is a little more obvious in its application. If an attorney acquires any interest adverse to a client's interests, it is difficult to see how the attorney can truly be the client's unqualified, zealous advocate. Needless to say, Rule 3300 is not intended to apply to the agreement by which the member is retained by the client, at least so long as the retainer agreement does not involve conferring upon the attorney an ownership, possessory, security, or other pecuniary interest adverse to the client. The best advice here is to keep your retainer agreements free and clear of those sort of business entanglements. Now, if you choose to enter into a business transaction with a client or acquire an adverse interest, that does not mean by itself you have violated Rule 3300. The rule contains 3 requirements which, if met, protect the transaction or acquisition from Rule 3300's strictures. First, the transaction or acquisition and its terms must be fair and reasonable to the client and be fully disclosed and transmitted in writing to the client in a manner which should reasonably have been understood by the client. Second, the client must be advised in writing that the client may seek the advice of an independent lawyer of the client's choice and is given a reasonable opportunity to seek that advice. Third, the client thereafter must consent in writing to the terms of the transaction or agreement. So in short, there must be full disclosure, opportunity to consult with an independent attorney, fair and reasonable terms, and written documentation of all of the above. And now our first case. Fair versus Bakhtiari, where the First District held that an attorney could not sue in restitution to recover the value of services he provided under separate business deals he had entered into with clients because the attorney failed to provide the conflict disclosures required by Rule 3300, which emphasized to the client that they may seek independent legal advice regarding the business deal. The client successfully secured a judgment voiding the business deals with the attorney, and the First District's decision leaves the attorney with nothing because of his violation of the rules of professional conduct. Our next case, in the matter of Marie Darlene Allen, was decided by the Review Department of the State Bar Court. In this case, the attorney was charged with a single count of misconduct due to her purchase of a residential duplex from a longtime friend and occasional client. The State Bar lost this case right out of the gate. The court never had to get to the issues of fairness and disclosure because the State Bar was unable to present clear and convincing evidence that the attorney was acting within the context of an attorney-client relationship at the time she entered into the agreement to purchase the duplex. The key to the resolution of this case was the court's legal conclusion that Rule 3300's limitations apply only during the period of time that an attorney-client relationship exists. Rule 3300 does not apply when an attorney enters into a transaction with a former client. The attorney in this case had previously represented the client in a number of separate matters, the last of those representations ending in 2002. The sale of the duplex took place in 2005. The bar argued that the sporadic and informal nature of the prior representations clouded the extent and duration of the attorney-client relationship, and the attorney was still representing the client in 2005. More directly, the bar argued that once a client, always a client, and that Rule 3300's limits were applicable even with respect to former clients. The Review Department of the State Bar Court disagreed. First, it emphasized that the duration of an attorney-client relationship is dependent upon the nature and scope of the engagement. It simply is not the case that once a client, always a client. Factually, the court found that the few sporadic instances of representation between 1999 and 2002 were insufficient to establish a continuing relationship all the way through to 2005. Second, while the court noted that Rule 3300 has on a few instances been expanded to former clients, where the transaction or acquisition involved harvesting the fruits of the attorney's prior representation, and there was evidence the client placed his or her trust in the attorney, there was no evidence at all that this type of conflict existed in this case. The sale of the duplex to the attorney had nothing whatsoever to do with the prior representations, and there was no evidence of undue reliance by the client on the attorney. So Marie Darlene Allen gets to keep the duplex as well as her clean State Bar record. Our fifth topic, preserving the identity of client funds and property. The lawyers in our next 3 cases were not so lucky as Darlene. All 3 of them were recommended for disbarment by the Review Department. Not coincidentally, all 3 involved substantial misappropriations of client funds in violation of Rule 4100 as well as other dishonest conduct. Because the consequences of violating Rule 4100 are so serious, usually disbarment if the amounts involved are more than trivial, it is worth taking a little time to review Rule 4100, which is the rule of professional conduct dealing with preserving identity of funds and property of a client. The basic rule is simple. According to Subdivision A of Rule 4100, all funds received or held for the benefit of clients by a member or law firm, including advances for costs and expenses, shall be deposited in one or more identifiable bank accounts labeled trust account, client's funds account, or words of similar import, maintained in the state of California, or with written consent of the client in any other jurisdiction where there is a substantial relationship between the client or the client's business and the other jurisdiction, close quote. As you all remember, the Board of Governors of the State Bar has adopted specific standards as to what records shall be maintained by members in law firms, and those records must be maintained for no less than 5 years after final appropriate distribution of account funds or other properties. Now, Rule 4100 is violated if an attorney commingles the members' or law firm's funds with trust accounts, with only 2 exceptions. First, member or law firm funds may be deposited in a trust account to maintain a balance reasonably sufficient to pay bank charges. That is, I think, simple enough. The second exception is more complicated. The rule provides that, in the case of funds belonging in part to a client and in part presently or potentially to the member or the law firm, the portion belonging to the member or law firm must be withdrawn at the earliest reasonable time after the member's interest in that portion becomes fixed. However, when the right of the member or law firm to receive a portion of trust funds is disputed by the client, the disputed portion shall not be withdrawn until the dispute is finally resolved, close quote. Okay, that gives us a quick review of Rule 4100. If a lawyer violates this rule, it is also usually the case that the lawyer has violated Section 6106 of the Business and Professions Code, which provides that the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, constitutes a cause for disbarment or suspension. That's why the penalties here can be so high so quickly. Now to our 3 cases of misappropriation. In these cases, we don't have any need for the fine interpretations of the rule. Instead, these are easy cases where the attorney was using funds from a client account to pay debts related to other clients or to pay the member's own debts. In other words, these cases involve hardcore dishonesty. If a violation of Rule 4100 involves a substantial amount of client funds, you should expect a recommendation of disbarment. So, our first case, in the matter of James Woodrow Nelson, where the attorney had been hired pursuant to a contingency fee agreement to represent the client if the client became a defendant in any adversarial proceedings connected to a bankruptcy. The client owned a 1/2 interest in his mother-in-law's residence, which was part of the bankruptcy estate, and the trustee sought to sell the residence. Ultimately, the bankruptcy court issued an order approving the sale of the residence. Now, on that same day, the attorney filed a notice of change of address in the bankruptcy court, falsely stating that his client had relocated, and the attorney listed his own address as his client's. The lawyer then filed a notice to ensure that any funds distributed by the trustee would be sent to the lawyer's office. The trustee sent the lawyer a $17,000 check from the proceeds of the sale of the residence, made payable to the client in care of the attorney. The attorney then directed his assistant to contact the client to come to the office to endorse the check, with the explanation that the check had to be processed through the lawyer's trust account. The client complied, and the check was deposited in the trust account on August 20. Between August 22nd and 29th, the lawyer transferred almost all of the funds into the lawyer's business account. The trustee subsequently informed the client that the $17,000 did not have to be placed in the lawyer's trust account, and the client sent the lawyer a letter demanding immediate payment of those funds. Well, the lawyer never paid the client and insists that the client still owes him $5,900 in attorney's fees. The hearing judge and the review department both concluded that the attorney violated Rule 4100 by failing to maintain the client's funds in the trust account, failing to promptly pay the funds to the client when requested, and misappropriating those funds as his personal property, which also constituted an act of moral turpitude in violation of Section 6106. There was no merit at all to the contention that the client owed the attorney some fees, since the attorney had never represented the client in any manner which had been contemplated by the contingency fee agreement. The review department concluded the lawyer should be disbarred, because his misconduct was egregious and consisted of many improper acts, most of which manifested dishonesty. Our next case, in the matter of Torbjorn Dahlen, is even easier. The attorney was hired to represent the client in divorce proceedings. After the marital home was sold, the title company issued a check for $69,000 made out to the attorney's client trust account. However, the attorney deposited the money into a separate interest-bearing money market account, which was not a client trust account. Ultimately, he made either improper withdrawals from that account without permission from the parties, and in violation of a court order providing that the funds could not be withdrawn without a written stipulation or order of the court. The attorney later explained he was transferring funds into safe, out-of-state accounts to avoid having those funds captured by the attorney's own creditors. Well, over a 2-year period, the attorney misled the court, the opposing counsel, and his clients and other creditors about the status of those funds. The court easily found that the lawyer had violated Rule 4100 when he deposited the funds initially in an account that was not a trust account, and then committed a misappropriation that violated a specific court order. That's a serious offense involving moral turpitude under Section 6106. The lawyer did not do his own case any favors when he tried to explain his failures by testifying that, despite handling a lot of trust funds, he had never even read Rule 4100 and knew nothing of the rules governing client trust accounts in 15 years of practice. Well, my friends, if you haven't read Rule 4100, I strongly urge you to pull it out after this presentation is over, or put me on pause right now so you can review it. The text is not very long, and if you don't follow the rule, you get in big, big trouble. Our final Rule 4100 case is in the matter of Mervyn Hillard Wolfe, who was found culpable of widespread misconduct in 4 client matters, including repeated misappropriations involving moral turpitude, an additional act of moral turpitude for making false statements in a declaration under penalty of perjury, collection of an illegal fee, failure to promptly pay client funds, and repeated failures to account to his clients. This is a terribly sad story of a lawyer who was just in way over his head when it came to the business side of running a law office. Early in his career, he had worked in law firms. He began solo practice in 1992, and between 1992 and 2006, he successively hired as many as 15 bookkeepers. Without providing any meaningful training or supervision, he required the bookkeepers to make deposits to and withdrawals from his client trust account, disperse funds to his clients, and review his bank statements. And even after his trust account checks were stolen, and despite having to repeatedly deposit personal funds into his trust account to cover shortfalls, he still did not assume control over his trust account or his firm's financial affairs. He testified that, quote, "I didn't want to be overseeing these people. I didn't want the responsibility, really," close quote. So instead, he said that, quote, "For years and years and years, I stuck my head in the sand and allowed people to run rampant in my office because I wasn't on top of things," close quote. Well, of course, the short answer to this is that you can't avoid the responsibility that comes with being a lawyer. Either you step up to the plate and make sure the trust accounts are being properly managed, or you get out of the business altogether. And this goes even for lawyers who join ongoing law firms. I urge you, don't be afraid of asking questions about the business side to make sure that your client's funds are being properly handled. At the end of the day, it is your client and your responsibility. You don't win any points with a state bar court by saying that it was someone else's responsibility. Well, our final topic today is fees for legal services. The rule here is pretty straightforward. According to Rule 4200A, a member shall not enter into an agreement for, charge, or collect an illegal or unconscionable fee, close quote. Unconscionability is determined under subdivision B of Rule 4200 pursuant to all the facts and circumstances with the aid of 11 factors that are listed in the rule. Things such as the amount of the fee in proportion to the value of the services performed, the relative sophistication of the member and the client, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly, and so on. Ultimately, you have to look to the cases to determine what is and is not illegal or unconscionable. And we have here 2 attorney fee cases to review. Our first case is Orange County Water District versus Arnold Engineering Company, where the 4th District rejected an attempt to disqualify the Water District's outside litigation counsel, who had been retained on a contingency fee basis to maintain a public nuisance action against the defendants. The defendants sought to disqualify the lawyers based on 2 California Supreme Court decisions holding that lawyers prosecuting public nuisance actions for the public's benefit have a heightened duty of neutrality that is undercut by the financial interest created by a contingency fee contract. The 4th District reasoned that those cases were not applicable here, since the Water District was not pursuing the action on the public's behalf. Instead, the Water District was seeking to recover compensatory damages it suffered allegedly as a result of the defendant's contamination of certain groundwater aquifers. In these circumstances, according to the court, the heightened duty does not arise, and the contingent fee contract does not create a conflict. Now, I'm going to be watching this case to see if the Supreme Court takes it up on review, because no matter what you say, the Water District is a public entity. And when it pursues its own interests, it presumably is pursuing the interests of the public. Our second case is Desert Outdoor Advertising versus Murphy, where the 1st District held that the scope of a lawyer's fiduciary duties does not require a lawyer to separately explain to a sophisticated business client that a new fee agreement, which the client needed to sign when the lawyer changed law firms in mid-representation, contained an arbitration clause which did not appear in the original fee agreement. Now, the new fee agreement was obviously longer and more complex than the first one. The fee arbitration clause was set forth in plain, understandable terms, and the new fee agreement was sent to the CEO of the business client as well as another lawyer who represented the business in related federal litigation. In these circumstances, the court held that the client's failure to read the contract before signing did not invalidate the arbitration clause. It is clear from the court's reasoning that this result might not obtain if the client were an individual or unsophisticated in complex business matters. So the better practice clearly is to draw your client's attention to an arbitration in a new fee agreement. Well, that's it for our special November edition on legal ethics. We hope you have enjoyed the presentation and have been reminded about a few of the things you are not supposed to do as a lawyer, as well as a few of the obligations to clients, the courts, and the public that help define and distinguish the legal profession as an honorable calling. I'm your host, Clark Kelso. Have a great day in the law.